Chambers. Hannah, do you want to briefly introduce yourself?
Hi, my name's Hannah and I'm a solicitor at the Centre and work with Ellie on our EUSS and access to benefits work.
And unless we've had any objections, Hannah, do you mind starting the recording?
I've just started it, yep.
Great, thank you. And just a couple of other housekeeping points before we get started. First is, can everyone please, if you're not speaking, turn off your microphones? And maybe also videos, because I think sometimes that helps with buffering and making things run smoothly. And then secondly, if you've got any questions, we will try and save some time for a Q&A at the end. But you can also, if you would like, put questions into the chat box as we're going along, and we'll pick up on those either at the end or, if we're really on it, as we're going through. And so I'm going to move on. Hannah, are you able to move on to the next slide, please? Sorry. Thank you. So today we are focusing on rights to social assistance benefits. And by that, I mean benefits that are means tested and designed to supplement income, and that are not based on social security or national insurance contributions. And at the moment in the UK, the main social assistance benefits are probably universal credit, pension credit, and child benefit. But it also includes older style benefits that are kind of being phased out, like housing benefits, income support, income-based job seekers allowance, income-related employment and support allowance, council tax reduction, and working tax credit and child tax credit. So all of those sorts of benefits. If we can just kind of go back, sorry, to the last slide. Thanks, Hannah. Hopefully by the end of this session, you will understand the rights to those benefits of EEA citizens and their family members who either have or are entitled to get settled or pre-settled status under the EU settlement scheme. Hopefully you'll also understand by the end of this session the right to reside test that applies to social assistance benefits. And you should be able to distinguish between the rights of different groups of people who are listed on this slide. So broadly speaking, I won't go through all of those groups now, but broadly speaking, the different groups are people who already have settled or pre-settled status, people who made a valid application under the EU settlement scheme before the deadline and are waiting for the outcome of their application. And within that group, the rights of those people depend on whether they were exercising a right to reside before the end of the Brexit transition period, so before the end of December 2020 or not, and on the type of family member that they are. Then the next group of people is people who have made an application under the EU settlement scheme, but made their application late, so out of time. And the final group is people who are entitled to make an application for settled or pre-settled status, but haven't yet made that application. And then at the end of the session, we're also going to hopefully give you some practical tips on how to demonstrate that your clients have a right to reside for benefits purposes. So moving along, the first section of this training focuses on what's known as the habitual residence test. So pretty much all social assistance benefits, as well as some other benefits, social security benefits in the UK, are subject to what's called the habitual residence test. So you'll only be entitled to get that benefit if you pass the habitual residence test. And if we move on to the next slide, for most benefits, the habitual residence test has two main parts. Firstly, the claimant has got to be actually habitually resident in the UK, and I'll come back and explain what that means in a second. And secondly, the claimant needs to have a right to reside in the UK. And again, I'll come back to that in a moment. But there are just a couple of exceptions to draw to your attention. The first is that some benefits don't have the right to reside test. And if we think about that kind of long list of benefits that I set out on a previous slide, the ones that don't have a right to reside test include disability living allowance, carers allowance, attendance allowance, and personal independence payment. So all of those, you need to be actually habitually resident, but you don't need to pass the right to reside test. But the other benefits mostly have the right to reside test as well. And the second point to note is that people who are exercising a right to reside as a worker kind of are automatically passported through the whole habitual residence test, and they don't need to show that they're actually habitually resident. And hopefully that will make a bit more sense in a minute when I go on to explain what actual habitual residence is. So the first part of the habitual residence test is that the claimants have got to be actually habitually resident in the UK. And for that, they need to have a settled intention to reside in the UK, or the common travel area, which includes Guernsey and Jersey as well, I think. And they need to have been here for an appreciable period of time. Now, a settled intention to reside in the UK means that they, in colloquial terms, that they intend to make their UK their home for the time being. They don't need to intend to stay here forever. And in terms of what counts as an appreciable period of time, there's no set time period. And some people might become actually habitually resident in the UK on their very first day here. But generally, case law suggests that a period of between 1 and 3 months is necessary. So the second part of the right to reside test that applies to social assistance benefits, the habitual residence test, is the right to reside test. And in order to pass the right to reside element of the habitual residence test, EEA citizens and their family members need to do one of the following. Either they need to have settled status, or they need to be Irish. That will be enough to have a right to reside. Or if then they have neither of those things, then they need to be exercising a qualifying right to reside in the UK. And we'll come back and look at what that means in a minute. Just to note briefly before we go on that British citizens all kind of pass the right to reside test as well. But here, obviously, we're focusing on EEA citizens and their family members. So I'm going to turn now to look in a bit more detail at the right to reside test. And I'm going to start by looking at how EEA citizens and their family members could show that they had a right to reside in the UK before Brexit. By before Brexit, I mean before the end of the Brexit transition period when EU law stopped applying in the UK. So before the end of December 2020. Sorry, there's a typo on that slide, but we will update and send the correct date. It should say the 31st of December 2020. And the reason for looking at the situation before Brexit is because the old rules continue to apply to some people after Brexit. So in order to understand how things work now, we need to know how they worked under EU law before Brexit. So before the end of the Brexit transition period, the main legislation that gave EEA citizens and their family members a right to reside in the UK was the Treaty on the Functioning of the European Union, which set out in broad terms free movement rights. Then Directive 2004/38, otherwise known as the Citizens Directive, which gave a bit more detail. And then, and this is what we will focus on quite a lot here today, the Immigration European Economic Area Regulations 2016, or the EEA regulations. And those are the UK law regulations that implemented free movement rights in the UK. All of that legislation was repealed in the UK at the end of the Brexit transition period, but some of it was kind of saved or kind of still in place for some EEA citizens and their family members, so it remains relevant. So if we just move on to the next slide, the EEA regulations, so the UK regulations that implemented free movement law that I mentioned before, those regulations gave EEA citizens and their family members a right to reside in the UK for immigration purposes if they fell into any of the following categories. So the first is if they were themselves an EEA citizen and they were either in the first 3 months of living in the UK, or they were a job seeker, so looking for work, or a worker, and we'll look in a bit more detail at what you needed to do to be a worker in a minute, or a self-employed person, and again, we'll come back to that. Someone with retained worker or self-employed status, and again, we'll come back to that in a second. Someone who was self-sufficient and had comprehensive sickness insurance, a student who was self-sufficient and had comprehensive sickness insurance, or someone with the right of permanent residence, and we'll look at permanent residence again in a minute as well. So an EEA citizen who fell into any of those categories had a right to reside for immigration purposes under the EEA regulations. The second category of people was the family member of an EEA citizen who fell into one of those categories. That family member had a bit of a technical meaning under EU law, but it included direct family members and some extended family members. Direct family members were spouses or civil partners. It also included direct descendants, so that means children, grandchildren, great-grandchildren, for example, who were either aged under 21 or were dependent on the EEA citizen. And direct relatives in the ascending line, which is a fancy way of saying parents or grandparents, great-parents, great-grandparents, etc., who were dependent on the EEA citizen. So direct family members of EEA citizens who were exercising a right themselves had a right to reside in the UK. And that also applied to extended family members. And extended family members were people who they needed to hold a residence card under the EEA regulations, and they could either be a durable partner of the EEA citizen or any other family member who was either a member of the household of the EEA citizen or dependent on them in the state from which they moved to the UK, so their state of residence, or who relied on the personal care of the EEA citizen on serious health grounds. So extended family members, durable partners, or other extended family members who had a residence card under the EEA regulations would also have a right to reside under the EEA regulations, so long as their EEA family member was exercising a right to reside. Then the next category of people who could have a right to reside were primary carers. And there are kind of three different types that we put on the slide here. So the first is Zambrano primary carers. And you may have come across them. They are primary carers of British citizens, and they had a right to reside in the UK if the British citizen who they were caring for would not be able to stay in the UK or the EU if they had to leave. The second category is Chen primary carers, and they are primary carers of self-sufficient EEA citizens. And the final category, which it's worth kind of drawing your attention to, is Tajara Carers. And a Tajara carer is the primary carer of a child who is in education in the UK. So they could be in primary school or secondary school, so long as the child has got at least one parent who's an EEA citizen, and that EEA citizen parent was a worker in the UK at some point in the child's life, and the child would be unable to continue their education in the UK if their primary carer left. So just to give an example, so for example, if there's someone called Beth and she's an Australian national, and she's the primary carer for her daughter Amy, who has lived in the UK all of her life. Amy's 8 years old and she's in primary school. Amy's father, Paul, is a French national, and he worked in the UK as a shop assistant when Amy was a baby. And even though he's not working anymore, because Amy's still in primary school in the UK, and because Amy wouldn't be able to continue her education in the UK if Beth, her Australian national primary carer, were to leave, Beth, the primary carer, is a Tajara carer and she has a right to reside in the UK. And that would also work if Beth, the primary carer, was herself the EEA national. So say she was a French national and she had worked in the UK when Amy, her child, was young. That would also work. So I appreciate it's quite complicated, but the reason for focusing on that is that that's quite an important way. Being a Tajara carer is quite an important way of having a right to reside for benefits purposes. And then the final category of people who could have a right to reside are people who'd acquired permanent residence. And we'll come back and look at that in a minute. So sorry for going through that in tedious detail, but I was trying to break down the different categories of people who had a right to reside pre-Brexit. So just moving on to the next slide. So what we've talked about, what I've been talking about just a moment ago, is the way that people had a right to reside for immigration purposes before Brexit. But not all of those rights were qualifying rights to reside for the purpose of claiming benefits. So for the purpose of claiming social assistance benefits, you can't rely on a right to reside that's solely based on pre-settled status. So if pre-settled status is your only right to reside, then that's not enough. You also can't rely or couldn't rely on a right to reside based on being in your first 3 months of residence in the UK. Also excluded from relying on a right to reside as a Zambrano carer, so primary care of a British citizen. And also for most benefits, including universal credit, it's not possible to rely on a right to reside as a job seeker. But although you can rely on a right to reside as a job seeker for the purposes of claiming child benefit, but for most benefits, it doesn't work. Moving on to the next slide. Thanks, Hannah. It's also, although these rights to reside on this slide are not expressly excluded from being qualifying rights to reside, it's also really difficult to rely on a right to reside as a student, a self-sufficient person, or a Chen carer. And that's because all of those rights to reside rely on being self-sufficient. And generally, the very act of claiming benefits means that someone is not regarded as being self-sufficient. But I stress there are some exceptions to this. So if you have a client that you come across who has been self-sufficient but needs to claim benefits for a short period of time, then feel free to refer them to us and we could give you some more advice on that. But generally speaking, it's very difficult. A second point to bear in mind is that to exercise a right to reside as a student or self-sufficient person, you also need to have comprehensive sickness insurance. But there is some good news on this front, and that's that in a recent case, the Court of Justice of the European Union found that entitlement to NHS care can count as comprehensive sickness insurance. Whereas previously it was thought that, or at least the UK government's position was that you needed to have private comprehensive sickness insurance that you'd taken out. I think there's probably going to be a bit of a battle between the Department for Work and Pensions and claimants about exactly the circumstances in which NHS care will count. But certainly the CJEU suggests that NHS care can be sufficient. And one point to note about kind of rights to reside as self-sufficient people and students is that even if somebody's not able to rely on a right to reside as a self-sufficient person at the time that they claim benefits, they might be able to show that they've acquired permanent residence through having been self-sufficient for a period of 5 years in the past. So self-sufficiency can be relevant, but we'll come on to that in a second. So now I'm going to look in a bit more detail at some of the ways that people can have a right to reside for benefits purposes. So the first is having a right to reside as a worker. And here the EU law test for being a worker applies. And to be considered a worker, a person has got to be pursuing activities that are genuine and effective, not marginal and ancillary. They've got to be performing those activities in return for remuneration. And that could be wages, or it could be benefits in kind. So it could be, for example, accommodation or like food and board and lodging. And thirdly, they've got to be working for and under the direction of another person. Anyone who meets the first two of these conditions, so they're doing genuine and effective work in return for remuneration, but is not working for someone else, will count as self-employed. And EU law says that the term worker has got to be interpreted broadly, but we found a common issue is that the Department for Work and Pensions interprets it quite narrowly, but you can challenge that by reference to UK and EU case law. So if we just look at the next slide briefly. So what the Department for Work and Pensions does is that it applies what it calls the minimum earnings threshold to determine whether work is genuine and effective. And that's a kind of two-stage test. So in the first stage, the Department for Work and Pensions looks at whether somebody has been earning a specific amount of money for a minimum of 3 months. And on the slide here, it says that in 2021 to 22, that amount of money was £184 a week. But for 2022 to 2023, that's gone up to £190. So we'll update the slides before we send them around and put in that new figure. And what the DWP says is that if somebody has been earning that amount of money for a minimum period of 3 months, then they'll automatically be considered to be a worker or self-employed. However, if they don't, then they'll go on to look at all the circumstances of the case to determine whether their work is genuine and effective. And it's here that EU law is particularly important to refer to, because EU law establishes, for example, that part-time work, sometimes as little as 10 hours of work a week, can be enough to count as genuine and effective work. And actually, in another case called Genk and Land Berlin, which is cited at the bottom of this slide, the court found that just 5.5 hours of work per week was, in the circumstances of that case, enough to count as genuine and effective work. And the circumstances of that case included that the worker had a contract of employment that entitled them to sickness and holiday pay. And taking into account all the circumstances of the case, just 5.5 hours work a week was considered genuine and effective. The second point to note is that really short-term work can also count as genuine and effective. So even though the Department for Work and Pensions has this kind of 3-month guideline, actually case law establishes that much shorter periods of time can be genuine and effective. And in the case of Barry, which is cited on the slide, someone who'd worked for 2 weeks at Wimbledon, I think as a ball boy, was found to have been in genuine and effective work. So just the 2 weeks work counted. The term worker can also include people who earn less than the kind of minimum subsistence level. It can include people who are on 0 hours contracts. And also the level of remuneration and the hours that the person works are not definitive. They've got to be taken into account along with all of the kind of rest of the circumstances of the case. Just moving on to the next slide. Some people who are not working or self-employed anymore can retain their worker status. So people who've got retained worker or self-employed status will also have a right to reside for benefits purposes. And regulations, it says regulation 2, but it should say regulation 6.2 of the Eea Regulations 2016, sets out a number of situations in which people might retain their worker status. The first of those is if they were working or self-employed and they have to stop work because of temporary incapacity to work, so temporary illness that stops them from working. The second is if they were working and then they become involuntarily unemployed and they register as a job seeker by which essentially you do by kind of claiming universal credit and registering as a job seeker. And if they have been working for at least a year before that, then they can retain their worker status indefinitely. But if they've only been working for less than a year, then under the UK regulations, they can only retain their worker status for a maximum of 6 months. And one point that is really important to emphasize here is if you've got somebody who's been made redundant, make sure that they register as a job seeker by claiming universal credit as soon as possible, because if there's a delay, that can stop them from being able to rely on this provision. If there is a delay, though, and there are good reasons for that, then they should be taken into account. So, for example, I've had clients who were victims of trafficking and who had experienced serious mental health issues, and the tribunal has taken that into account and held that they didn't unduly delay in registering as a job seeker. But it's really important that people register as a job seeker as soon as possible after they've become unemployed. Another group of people who, I won't read out everything on this slide, but another kind of big group of people to mention is that women who stop work because of the demands of the late stages of pregnancy and the aftermath of childbirth can also retain a right to reside as a worker or self-employed person for a reasonable period of time, so long as they intend to return to work afterwards. And this applies not only to workers, but also self-employed women and women who had retained their worker status at the time that they reached the late stage of pregnancy. So, for example, if you had a woman who stopped work because of temporary incapacity because of illness, and then, whilst she was off work and had retained worker status, reached the late stages of pregnancy, she could switch into this category of person with retained worker status. In terms of what counts as a reasonable period, it depends on the circumstances of each case. Normally, the kind of guideline is that you could stop work 11 weeks before your due date and then stay off work for a period of 52 weeks. But it depends on the circumstances of each case, and some women will have to stop work earlier in their pregnancy because, perhaps, for example, because of a disability or illness they have, or because of risk to the child. And in those circumstances, they ought to be able to stop work and retain their worker status earlier. Moving on to the next slide. So I mentioned earlier that another way that people can have a right to reside that qualifies for benefits is if they have the right of permanent residence. And there are two main ways of getting permanent residence. The first is the 5-year route, which this slide deals with. But secondly, some people are entitled to early permanent residence. So just looking briefly at the 5-year route. So before Brexit, EEA citizens and their family members who exercised a right to reside in the UK for a continuous period of 5 years automatically acquired permanent residence. They didn't need to make an application or get a card, they would just automatically get permanent residence. They could exercise a right to reside, for example, by being an EEA citizen who was in the first 3 months of their residence in the UK, or was a worker, self-employed person, person with retained work or self-employed status, self-sufficient person, student or job seeker, or through being the family member of an EEA national who fell into one of those categories. It's important to note, though, that for the purposes of getting permanent residence, it wasn't possible to rely on being a Chen primary carer or a Tajara primary carer or a Zambrano primary carer. None of those count for the purposes of permanent residence. But any other ways that you could exercise a right to reside for immigration purposes do count for the purposes of getting permanent residence. So you need to be doing that for a continuous period of 5 years. Continuous generally meant without absences of more than 6 months in any 12-month period. But it was possible to have one absence of up to 12 months for important reasons. And that could include things like pregnancy, childbirth, or serious illness. But it's not it's not limited to those things, and other important reasons should be taken into account as well. And one thing to note is you can rely on any 5-year period, so long as the person in question hasn't been absent from the UK for more than 2 years since then. And actually now, under the withdrawal agreement, that's increased to 5 years. So in terms of permanent residence, some things to look out for some groups of people. So there's a group of countries called the A8 countries that joined the EU in 2004. And for those people, up until the 1st of May 2009, in order to exercise a right to reside as a worker, they needed to have registered their work under the Workers' Registration Scheme until they'd completed 12 months registered work. So if you've got someone who you're advising who's trying to show that they've got the right of permanent residence based on periods of time before the 1st of May 2009, which might seem unlikely, but it has happened with some of my clients recently, then you need to look at whether their work was registered. But it's important to remember that that requirement did not apply to self-employed people. It was only workers. And it only applies to periods before the 1st of May 2009. The UK government tried to extend it until 2011, but the Supreme Court recently found that that was unlawful. Similar issues applied to so-called A2 nationals, that's nationals of Bulgaria and Romania. They had to register their work until the 31st of December 2013. And also, and not on this slide, but also Croatian nationals, and they had to register their work until the 30th of June 2018. So I've talked about the kind of 5-year route to getting permanent residence. Some people can qualify for permanent residence before 5 years, and those ways are set out on this slide. And I won't read through all of the slide, but the key things to note there are that if there's an EEA citizen who was working or self-employed but stopped work, and when they stopped work, they'd reached retirement age, then they would get permanent residence upon stopping work, provided that they'd worked for the preceding 12 months and had resided in the UK for a continuous period of 3 years before stopping work. And it's important to note that during that 3-year period, there was no need for them to have been exercising a right to reside, so long as there was a 12-month period when they were a worker. And the second group of people that comes up quite often amongst our clients are EEA citizens who are working or self-employed and stopped work because of permanent incapacity to work. So for example, they might have had a traumatic brain injury that left them permanently unable to work. They would acquire permanent residence when they stopped work, so long as they'd resided in the UK continuously for more than 2 years before they had to stop work. And again, so long as they were a worker just before they stopped work, there's no need for them to have been exercising a right to reside for the rest of that 2-year period. And if they stopped work because of an accident at work or an occupational disease, then, and there are various other conditions, then they don't need to have been here for 2 years before they stopped work. I won't, and then family members of EEA citizens who fell into those groups will also acquire permanent residence early, provided that they were residing in the UK immediately before their EEA national family member stopped work in the UK. And some family members will also get early permanent residence if their EEA citizen family member was a worker or self-employed person who died while working in the UK, but before acquiring permanent residence. And there are various conditions that apply there, which is set out on this slide. So we've looked at, in some detail, the ways that people could have a right to reside for the purposes of claiming benefits before Brexit. And now we're going to look at the situation after Brexit. And the first group of people to look at here are people with settled status. And people with settled status, as I mentioned earlier, will need to show that they're actually habitually resident in the UK, but settled status gives them a qualifying right to reside in the UK. The second group of people that we're going to look at are Irish citizens. And again, this is really quick. Irish citizens need to be actually habitually resident in the UK, but their Irish citizenship gives them a right to reside in the UK. So long as they're actually habitually resident, they will pass the habitual residence test. And now I'm going to pass over to Hannah. Sorry, Hannah, I've gone on for a long time, to take you forward.
Thank you very much, Ellie. So yeah, that's right. As Ellie said, there's various categories of people now post-Brexit, and people with the situation with regards to people with pre-settled status is a little bit more complicated than those with settled status. So as we mentioned at the start, pre-settled status in itself is excluded from being a qualifying right to reside for the purposes of the right to reside test. So we've set out the regulations that provide for that there. And what this means is that if you have pre-settled status, you also need to show an extra independent qualifying right to reside on top of your pre-settled status, which qualifies you to claim benefits. And so this is where the Eea Regulations 2016 and everything that Ellie has just been talking about comes in, because all those pre-Brexit provisions that Ellie was just describing are saved for people who have pre-settled status, and they continue to rely on those regulations and all of the case law that Ellie just talked about when they want to claim benefits. And that's provided for in these transitional saving regulations, Schedule 4, which says that those regulations continue to apply to people who have pre-settled status. And that includes people who were residing in the UK before Brexit, but also those who moved to the UK after Brexit. So that could be, for example, the EEA national spouse or child of another EEA national already living in the UK, who arrived in the UK in 2021, 2022, who's now got pre-settled status and is exercising a right to reside in their own right. So they might be working, have retained work status, etc. And that applies for as long as their pre-settled status remains valid. So that's normally from 5 years from the date that pre-settled status is granted, unless it's revoked or lapsed, for example, if a person leaves the UK for 2 years at a time. So just to recap, if you've got pre-settled status, you can claim benefits if you fall into one of the following categories. You're an EEA citizen yourself, and you've got a qualifying right to reside under the EEA regulations. So you're someone who falls into any of the categories that Ellie has just talked about. You're not an EEA national, but you have pre-settled status and you're the family member of an EEA citizen who is exercising a right to reside. So you're the family member of someone doing any of those things Ellie just talked about, or you're the Tajara carer, the primary carer of a child in education of an EEA national worker. So they're the 3 categories of people with pre-settled status who can apply for benefits. And in terms of what it means to be a family member, the definition is, again, the same as Ellie's already discussed. It includes a spouse or civil partner, a direct descendant or a dependent direct relative in the ascending line, so parent, grandparent, etc., of the EEA national who is exercising a right to reside. The test is slightly different if your EEA sponsor is a student. In that case, the student can't sponsor somebody in their ascending line, only their dependent children, spouse, civil partner. And that's the categories of people with pre-settled status. Some potential issues is that the way that the regulations have been saved appeared to mean that someone who's an extended family member, and again, Ellie already discussed the definition of extended family member, but that might be a durable partner, so an unmarried partner of an EEA national, or other dependent family members, are excluded from this test. So if you do have someone who's an extended family member rather than a close family member, feel free to refer their case to us. So as I've just said, you have to really show that you fall into one of those categories to claim benefits as someone with pre-settled status. However, there is one alternative argument that you might want to make if you're dealing with a client who has pre-settled status and there doesn't appear to be any way to argue that they fall within one of those categories. And that would be to rely on their charter rights. So that's their rights under the EU Charter of Fundamental Rights. I'm not going to go into this in too much detail because it is quite a complex area and there are ongoing cases concerning exactly how this test might apply. But we wanted to flag it because if you do have any clients that you think might fall within this category, then we would say please do refer their case to us so we can try to support them to make these arguments. So essentially where this comes from is that prior to Brexit, a case was brought by tribunal in Northern Ireland, actually. They referred a case for preliminary ruling by the Court of Justice of the European Union. And what they asked in summary was whether pre-settled status alone is sufficient to constitute a right to reside to claim benefits. And in short, the CJEU said no, it's not. But one potential argument that they could make was to say that before the relevant authority, so potentially the DWP or the local authority, could refuse benefits, they must first assess, would that refusal expose the person claiming benefits to an actual and current risk of violation of their fundamental rights under the Charter? And that includes their right to dignity, their right to private life, and the best interests of the child. Now, it's not entirely clear what that means. It's quite a vague test, but it is likely that it would be quite a high bar to show that refusal of benefits would breach your fundamental rights. You would have to demonstrate that you'd suffer quite significant hardship. And another issue is that this case concerned the situation prior to the end of the transition period, when the Charter of Fundamental Rights still applied in the UK. So the DWP and the government seem to be arguing that the Charter is no longer relevant for cases post-Brexit. Air Centre and various other charities are currently involved in some appeals before the Court of Appeal and the Upper Tribunal, where we're arguing that the Charter does apply to people who fall within the scope of the withdrawal agreement. So it's certainly an argument that's worth making if it appears that the person you're working with has pre-settled status and no other qualifying right to reside, and they would face significant hardship if they were not granted benefits. So we will keep you updated on how these cases develop, and certainly after we get any judgments, we can send an update to Nina and Mandy and ask them to circulate these updates to you. But to look at an example of a kind of case that might fall within this category, it might be a victim of domestic violence who's the primary carer of a child, who's not old enough to go to school, so they're not a Tajara carer. They can't go to work because of their childcare responsibilities. They can't pay for childcare because they can't go to work. They've not got benefits. So this kind of case engages the best interests of the child. It's not a case where the DWP could simply say, you can start working, because the person's not in a position to do so. And they're certainly not in a position to rely on their former abusive partner, for example, for support or childcare support. So that's people who have pre-settled status. Another category of people are those who've made an EUSS application, but that application is still pending. And this covers quite a lot of people. There are quite a few people whose application is taking a while to process and have been waiting on an outcome for sometimes months, even years for some people. And this category of people are further divided into two subcategories: those who are covered by what's known as the grace period regulations, and those who aren't covered by the grace period regulations. And I'm going to go on to cover who exactly falls into those categories. But just to say at the outset that this is quite a complex area governed by a tapestry of different regulations and guidance. And if it seems complicated, that's because it is complicated, and it appears that the guidance is actually quite confusing, and various charities have written to the DWP asking for further guidance and clarification. So again, if we do get any updates, we can circulate these to you. So people with a pending application who are covered by the grace period regulations. The grace period regulations provide that the EEA regulations, so the test that we've just talked about that applies to people with pre-settled status, also applies to EEA citizens and their family members who exercised a right to reside in the UK on or immediately before 31st of December 2020, or who'd acquired permanent residence by that point, and who have made a valid in-time application to the EUSS, but that application is still pending. And in time, for the purposes of these regulations, is defined as the 30th of June 2021. So to fall within the regulations, it's necessary to look at what was the person doing prior to Brexit. Were they exercising a right to reside? For example, were they a worker, self-employed person with permanent residence before 31st of December 2020? And did they apply to the EUSS by the 30th of June 2021? If both those conditions are met, then the EEA regulations continue to apply for them for as long as that application remains pending, and if their application is refused, until they have appealed that outcome and the appeal is finally determined. So that again means everything Ellie talked about at the start applies to this category of people. And if that is the case, then they just need to show that they passed the qualifying right to reside test at the date of their application for benefits, universal credit, etc. So they can do that by showing that they fall within those three categories that we've already discussed. The second category of people are those who are awaiting the outcome of an EUSS application, but that are not covered by the grace period regulations. So that means those who weren't exercising a right to reside prior to Brexit, or those who made an application from 1st of July 2021 onwards. And in respect of this group of people, there haven't actually been any regulations introduced to protect their status. The protection that they get in terms of accessing benefits all comes from DWP and Home Office guidance. I've put a little note on the slide here just to say that the position's not the same in respect of their right to work and their right to rent in the UK. So late applicants to the EUSS have a right to work and a right to rent under the regulations that I've included on the slide there. So they have a bit more protection under regulations, whereas the situation in terms of benefits is a little bit more complicated. So what happened is in November 2021, the DWP published some guidance about claimants who made a late application and who aren't protected by the grace period regulations. And there's a link to that guidance on this slide. And we would recommend that if you're ever supporting a late applicant to the EUSS to claim benefits, that you include a link or a quote or cite directly from that guidance. So what happens under this guidance depends on whether you're supporting someone who's already receiving benefits or someone who's making a new claim for benefits. If you're working with someone who already is receiving benefits and they've made a late application to the EUSS, their position should be protected under this guidance. So they should continue to receive their benefits as long as they can provide proof of their late application to the EUSS. The situation is slightly different for new claimants. What it provides is that if a person has made a late application to the EUSS, they will be able to claim benefits if they fall within the scope of Article 10 of the withdrawal agreement, and we'll come on to what that means in a second, and they have reasonable grounds for applying late to the EUSS. In terms of having reasonable grounds for applying late, the guidance says that if the Home Office has issued them with a certificate of application, the DWP should accept that they have reasonable grounds and they don't need to look into that condition any further. And they can access benefits from the date that they made the application to the EUSS, which has subsequently been validated by the issuing of a certificate of application. So as soon as the person has a certificate of application, they should be able to access what's known as a share code, provide that to the DWP to provide evidence that they've applied to the EUSS, and that acts as proof that they've got reasonable grounds for applying late. And there's similar guidance for local authorities in terms of accessing housing benefit and homelessness assistance. That second condition was that they fall within the scope of the withdrawal agreement. And generally that means, well, I've listed the categories of people on the slide. It's people who were exercising a right to reside in the UK before the end of the Brexit transition period, their family members, and the other categories of people listed on this slide. So there's also some other guidance published by the Home Office, which relates to people who are expected to be granted settled status under the EUSS, who have a pending application. And what this guidance provides is that if a person has submitted a late application and they can show that if they were granted settled status, they would be eligible for settled status rather than pre-settled status, then they are eligible to access benefits on the same basis as any other British citizen. Now, this isn't provided for in any other piece of guidance as far as I'm aware, but it's certainly an argument that's worth making if you're working with someone who's lived in the UK for 5 years or more, and it's not evident that they've exercised a qualifying right to reside for that period of time. Rather than arguing that they're eligible as a person with a qualifying right to reside, if you can't see that the argument is going to work, one other option would be to quote from this guidance and to say they are eligible on the basis that if granted status under the EU settlement scheme, they would be granted settled status. And what you would need to do is provide evidence of 5 years residence in the UK. And that could be any form of evidence of residence. It could be medical appointments, housing contracts, bank statements, anything to show they were simply here, rather than having to show they were exercising a right to reside. I'm conscious of the time, so I'm just going to run through this quite quickly, but this is for people who haven't yet applied. What's happening at the moment is the DWP is contacting people individually if they already are in receipt of benefits and telling those people they need to apply to the EUSS to continue to receive their benefits. We have started to see an increase in this happening where people are threatened with suspension or termination of their benefits claims unless they apply. And so in that situation, the person just needs to submit an EUSS application as soon as possible. So as we say here, just encourage that person to apply. What happens is, to prove you have a pending application or you've received status under the EUSS, you need to generate what's called a share code. And you can only actually generate a share code once you've been issued with a certificate of application. And that means that the EUSS team have checked your ID, checked your photo, done the initial checks to show the application's valid, and then they deal with all the other conditions to do with residence after you've got your certificate of application. So it's important to try and get that as soon as possible. So one thing that you might want to do is, if you're working with someone who's only just applied to the EUSS, you can contact the EUSS Resolution Centre, and I've put a link to their contact details there. Call them up and just say, this person is needing a share code to apply for benefits. Can you please validate their application as soon as possible? Make a note of any vulnerabilities they face, and you can ask them to just try and process it ASAP so that they get their share code and their certificate of application. As soon as they get it, provide that to the DWP. People who aren't eligible for the EUSS and who haven't applied are outside of the scope of this presentation. I'm conscious that we've come up to time. The last few slides are all about practical tips on obtaining evidence and evidencing EUSS status, and we did include quite a lot of information on these slides so that if we didn't get through it, you could refer to them in your own time. I might just whiz through some of the content. So this is the part about obtaining a share code. This is the way that the DWP asks for evidence of EUSS status. They're accessed online. I've put a link to the way in which you access them. The person needs to log in using their ID document, and they'll be sent a code to their phone or their email address used to apply to the EUSS, and they need to share this code with the DWP. Just to note that there are two different ways to log in. If a person has a pending EUSS application, they can log into their EUSS application through a different link, or they can log into the View and Prove service, and it's the View and Prove service that they need to evidence that they've got a pending application. There's some information on making subject access requests here. This is all the different ways that a person can try and obtain evidence to show that they are exercising a qualifying right to reside, as we discussed at the start. So as Ellie said, the test to show you're a worker is very, very broad, and so is the evidence you can supply to show that you're a worker. Obviously, payslips, HMRC records are ideal, but if a person doesn't have that, they might have been working cash in hand, they might have been working in a more informal situation, a letter or email from their employer, or even evidence of income going into their bank statements could be used to show retained worker status, try and get any medical records or sick notes that show that they had an illness that impacted their right to work, write this to the DWP. If you can't get any evidence of their work, you can also ask the DWP to try and obtain records, like this case of Care, 2004 case, which said that the DWP also has an obligation to assist. For example, if you're working with a child who has a right to reside based on their mum or dad working, they don't have a relationship with their mum or dad anymore, they need records of their mum and dad's work, you can ask the DWP to look for their HMRC records themselves by explaining why you can't access the records. And then this is just some tips on challenging a benefit refusal. So first of all, you need to ask for a written explanation of why the claim's been refused, and then request the mandatory reconsideration from the DWP. In these slides, we included so much information because it's really helpful just to copy and paste references to the legislation, the cases we reference. For example, if you're saying someone has a right to reside as a worker, quote those cases in the slides on worker status, saying that the test is broad, 2 weeks work counts as work, etc., and submit any further evidence you have of that work or retained worker status, etc. If the mandatory reconsideration is refused, then it's possible to appeal to the Social Security Tribunal within 1 month. There's no fee to appeal to the Social Security Tribunal. It can be quite a long process, but often you do find in many cases the tribunal is willing to accept a person has a qualifying right to reside in cases where the DWP might not have. So one example is we consistently have cases where we argue people who've worked in a trafficking situation count as workers and have a qualifying right to reside. The DWP consistently says they don't, the tribunal consistently says they do. So if the DWP is obstinate in its refusal, don't lose heart and think that's the last hope, because the tribunal often does apply a different approach in cases such as that. Apologies, that was a real whiz through at the end there, and we will circulate the slides and the recording, but I don't know if anyone has any questions for either of us at this point. Feel free to put them in the chat box or to come on video and ask.
Thank you, Hannah, and thank you, Ellie. I'm keeping an eye on the chat. There aren't any questions at the moment. We're just 4 minutes over. Is there anybody who just give it time for anybody to raise any questions? Feel free to unmute yourselves or put a question in the chat.